Thank you. Minor items not on the agenda. Hang on a minute. Councillor
Thanks. If
Hewitt.
you can just add to Argyle East School Community Planting Day, please.
A what?
Argyle East School Community Planting Day.
Okay. Right, I'll work around the table. Councillor Scott? Business Hub. Thank you. Sorry, Councillor Bevan.
Water bottling consents.
Bottling consents. Councillor Belford.
Burning rubber.
Burning rubber. Okay.
Strategic plan refresh.
Beg pardon?
Strategic plan refresh.
Okay. Nothing further? Okay, thank you. Right, let's get into the agenda then. Legal advice on the Ruataniwha water storage scheme, documents and all related legal matters. And I think Andrew Wears is here. Is he? Oh, there he is. Good morning. So,
While he makes his way up, can you explain how we're actually supposed to do this? We have a public excluded document that I myself have about 15 questions about.
sure. My intention would be let's deal with what's in front of us here now. I'd suggest we leave this on the table until we get into public excluded, and then come back to the recommendations in public after we do the PE stuff. So that would be that's how I intend to handle it. So
So you're not entertaining any questions
yes,
about this?
a whole heap of questions, but not in the public session,
That's what
but
I mean.
certainly in
So
the
not
private.
now?
Not now, no. But if you've got any other questions, I've had a couple posed to me by councillors that they would like to ask in public, so I think that's how we'll attack it. Anyway, I'll hand over to the Chief Executive to kick us off.
Thank you, Mr Chairman. Councillors, you have already become acquainted with Mr Wears from Sainsbury Logan Williams, who has appeared in front of you before to provide advice on this matter. But just to reiterate, this is one of the requirements around confirming the decision that you made on the 25th of June 2014, 2 years ago, to invest up to 80 million in the Ruataniwha. And one of those requirements is that you're subject to being satisfied with your own legal advice on the Ruataniwha water storage documents and all related legal matters. We have now at the point where those legal documents are finalised. Clearly, the concession deed being the only one of the documents in this paper that the council itself is actually a party to, it was important that we got this document to the point of being finalised, and that could only be done once we knew who the two institutional investors were, and they have had their input into as well, as they indeed, as part of Ruataniwha Water Limited Partnership, are the other parties to this agreement. So we now have these documents, as Councillor Belford has identified. You have copies of them in full. They will be made public after financial close, but they're not in a position to be made public yet. Mr Wears has gone through each of those documents, well, particularly the concession deed agreement and the project agreement, and looked at those from a councillor perspective. While the project agreement, as I said, we are not a party to, HBRC is, and as the owners of HBRC, we need to be aware of what the potential risks or liabilities are around their commitments in that. I am going to hand over now to Mr Wears to work through and obviously to answer questions on these documents that are able to be asked in open. It is a challenge because these are in public excluded, being able to complete this item in a sensible way, but it was felt that it was best to have any specific questions on the document covered in public exclusion, and then council will move back into open following that to make its decision. So that, I imagine, for the benefit of anyone who's wanting to hear that outcome, will be later this afternoon. I'll hand over to Mr. Wares.
Good morning. I'm assuming that the chairman will give me the nod if I'm straying into areas that I ought not to in terms of the review.
The nod. You're looking for the nod, okay.
You will have had a copy of the paper and the letter that I wrote on these documents. I hope that they are self-explanatory. That was my intention, was to try and encapsulate what is a lengthy document in the terms of the concession deed. It runs to many pages. And to summarise what I thought would be the critical issues for the council. I'm happy to go through my notes with you if that's what you would wish, or alternatively I'm happy just to take questions from council.
Well, just let's get a head around that, your request. What's the view of the table? Should we go through his... You're happy to go through his notes first, is that... You're happy to take it as read and ask questions, okay. So you have a question, Councillor Belford?
I guess my first question is, in what circumstances can the deed be amended, and how? Once it's been officially approved for the first time, as time goes by.
Mr. Chairman, before you answer that, I think it's appropriate that Mr. Wares should walk us through his paper, because there are a very large number of people in this room who won't have the paper in front of them, so they should at least be given some knowledge.
That's a very good point, Councillor Dick. But let him answer this question, perhaps, and or maybe he'll answer it on the way through. But yeah, I think for the benefit of the gallery, Councillor Dick, I think you did right. He should take us through it, so thank you for that. So there you go.
Okay, the answer to Councillor Belford's question, if I start with that, is that the deed is amendable, if that's even a word, able to be amended by the parties, by deed, in writing. So at any time, by agreement, the parties can choose to vary the concession deed. So there's only a one-line clause dealing with that, and it requires amendments to be in writing.
So that, for example, a discussion in this about environmental flows, as a for instance, if we were to proceed, as we're probably going to decide later today, to examine additional flows, for example, the prioritization of those flows is something that could be amended into this agreement at that time, let's say in November.
Correct. By contract, parties can do what they wish.
Okay, thank you. So take us through your paper for the benefit of the gallery as much as us. Mr. West?
All right, so the concession deed is a document between the Regional Council and the Ruataniwha Water Limited Partnership. It's focused on supervision of works and operations. Sorry, let me just start with, as the name suggests, the concession deed is the document under which the council grants a concession to somebody to do something. And in this case, it is granting the Ruataniwha Water Limited Partnership the ability to build and operate a dam. And so the matters that the concession deed deals with are supervision of works and operations, audit and compliance rights of council, reporting obligations on the part of the limited partnership. It deals with water distribution and priorities. It has what are called step-in rights for council. If something goes terribly wrong, then council could step in place of the limited partnership and take control of the dam. And there are termination rights and consequences. So my paper addresses a number of matters that I thought would be important to council as in its governance role. And the first is a very clear statement in the document that the council's regulatory capacity is unconstrained by the document. In other words, any statutory or regulatory rights, functions or powers that council has as regulator are unaffected by the deed. So nothing in the deed is intended to restrict in any way the council's powers in that regard. The next matter was the monitoring of the performance of the limited partnership. These are necessarily relatively high-level powers, but I believe that the council has appropriate powers to monitor the performance of the limited partnership. The limited partnership contractually commits to council to build the infrastructure and operate the infrastructure in accordance with good industry practice, which is a defined term. And generally those, as you've heard from Mr. Newman, those obligations are often passed on to subcontractors. So, for instance, in the case of construction, you would expect the party doing the construction to have the risk around ensuring that occurs. But even where there is a subcontract, the limited partnership remains contractually liable to council for performance. And in addition, the limited partnership has a number of reporting obligations to council, and council has audit rights to verify compliance by the limited partnership with its obligations under the deed. The next matter was to do with financial liability of council under the deed. So council is responsible for making payments to the limited partnership in two circumstances. The first is where a compensation event occurs. This is, I use the word advisedly, but comparatively normal in the public-private partnership space, where one of the parties, in this case the council, is also the regulator and is able then to make regulations that adversely affect the operation of the dam. So the scenario would be that council makes a decision in respect of the catchment for the dam, particularly with regard to farming operations, that is outside of what is an objective normal standard in New Zealand, and that the impact of that is that the dam is unable to operate in the way in which it was envisaged, and in that case council is potentially liable, well, is liable for what are called qualifying losses. So as regulator, you make a decision that's outside the norm, then council does that with its eyes open and knowledge that it may be responsible to the dam operator for the consequences, the losses that flow to the operator from that. There is a second scenario under which council may be responsible to make a financial payment to the limited partnership, and that's where there is a termination event and council terminates the deed and then takes back ownership of the infrastructure. That's essentially where there is an event that is not the fault of the LP. So sorry, I misspoke. Those circumstances are limited to where a RWLP default results in serious health risk to health and safety of persons or the structural integrity of the infrastructure, or there's a prolonged event of force majeure, which is act of God or something that means that the party can't operate the dam. And in those circumstances where council determines to terminate the dam, terminate the concession deed, it will pay the residual value of the infrastructure, which is assessed according to the calculation in the deed. And again, that is comparatively normal in this space. So you are effectively obtaining the, you're taking over the capital of someone else. The next item
Excuse me, can we ask questions as we go through this?
I had one for the previous one.
Yeah, so I'm just, could you explain what happens if there's an earthquake and the dam gets destroyed or partially destroyed? Who's liable and what happens?
Liable for what?
For any damage that's caused as a consequence.
The limited partnership is effectively has got the risk in the dam during the concession period. So the limited partnership would be responsible for would carry that risk and would be responsible for fixing it if it's fixable.
Your question to that?
No, Councillor Graham.
I just have a question on that. So, as a hypothetical example, there's an earthquake and the dam is seriously damaged, but doesn't explode. But experts say that it could, and there'll be loss of farmlands and houses and life. Are you saying that if we say, look, guys, this has got to be stopped and fixed, that we have to buy the capital out?
You have to buy the residual value, but of course, if the cost
residual capital,
because of course, if the cost of the fix is more than its value, then the residual value will be nil. But yes, I am saying that. I am saying that you have to pay the residual value if you take it over in the event of a force majeure. But the residual value is it's then market value, or it's then assessed value.
but it's worthless.
Correct. So you won't be paying anything. It may in fact
Okay.
have negative value.
So you'd have to get a valuer in to value it
Yeah,
up.
there's, as you would imagine, some robust valuation mechanism.
Councillor Barker.
On the make good the loss, presumably the limited partnership's only asset will be the dam itself. If the dam is broken, flooding is caused, the dam is of no value. How is it then going to make good the loss? Because its only asset is gone. Will it have to be, is it required to have insurance to cover this?
It's required to have insurance. Whether the insurance is sufficient to meet the costs of repair, I guess, remains to be seen. So in a hypothetical situation, I think that one of the commercial realities here is that if there was an event of that nature, while there was still bank funding, it's highly likely that a bank will be motivated to take action to secure its investment, so that it won't simply be there is another party, in other words, in all of this, where who will be mightily interested in whether or not there is value in this thing that might repay their debt.
Could I just say to you, you're not offering me any reassurance here, because the investor has, they put the money in, they've got the dam breaks, enormous damage, then who's going to pay the bill? You're saying they have to have insurance, but it could be just a standard fire and loss of property insurance, like a household insurance property, the minimum insurance, and the gap between what is required and what they have, who's going to meet that? The bank's not going to stump up for that. I've never seen a bank.
It could
do
be
that.
total replacement insurance too, Councillor. I mean, you don't
Well,
know. I mean,
The replacement of the
You-
dam, but just
chasing us in a certain direction. I have a question on the previous conversation around a decision outside the norm. How explicit is that covered in the deed? Seeing we're taking questions now, because a decision that the future council walks into with its eyes open, that is outside the norm, is it outside an MPS, or maybe
Yes.
maybe staff could
Yeah, look,
answer that? Yeah.
Mr. Chairman, I think that's probably something that, broadly speaking, yes is the answer, but if you want to discuss that in detail, I may have to do that in public excluded.
In public.
Yes. You referenced it in terms of compensation events, and I think in view of the public audience we do have here, there's some general description of what you're saying there is that the water user agreement, the whole erection of this thing is built upon industry best standards being in place to deal with the environmental mitigation aspects of this. Industry best practice is not something that is generally inputted to a great deal by, for example, the environmental community. So views as to what represents what's achievable in terms of environmental mitigation would perhaps be a contentious issue in the future if it were found to be necessary to ratchet up the environmental requirements. That is all spelled out in excruciating detail in the water user agreement or the new water user agreement that we have not yet had the benefit of your counsel on. So that's what is set up here. You say on the one hand there's where our regulatory authority is not compromised, but we would be living under the shadow at all times of what is considered to be industry best practice, because if we step over that line, we're opening ourselves up to all sorts of legal challenge, including the right of water users to exit their agreements. Is that not basically the scenario?
You're certainly opening up the prospect of a compensation claim by the dam operator where their ability to operate, to make money from the dam, is compromised by a change that's implemented by the council.
Through you, Mr Chair, there are a number of qualifying scenarios to meet the term compensation event, and the one that you've just described, Councillor, is but one of them. So there are there is more certainty around national documents, but there's also the concept that if council was to discriminately regulate against those who operate under the scheme consents versus the rest of the normal public, then that's another qualifying event as well. So the industry good practice guidelines is but one of those.
Aware there are consultants around who are frequently talked about, and their case studies are presented in Farmers Weekly and so forth and so on, and at agricultural workshops and field days where there are people working with, let's say, dairy farmers who are showing that you can have substantial diminishment of environmental footprint while increasing farm profitability. I'm not sure those practices are embraced, let's say, in Dairy New Zealand's best practice. So if we want to move toward what we consider to be effective, better, proven practices, who's to judge where we can go, where we can't go, because as we'll get to in the water user agreement, there's a lot of carefully worded language as to taking HBRC basically off the hook to enforce those kinds of requirements.
Councillor, again, I don't think that necessarily legal documents are going to force any change of behaviour necessarily that you require. I think there are a number of other means and mechanisms by which council, as a regulator, can help implement the types of changes that you've referred to as providing, for example, farm advice through the farm environmental management plans that would be required, etc. I'm not sure that the concession deed in this case is going to particularly address all the specific concerns that you may have. What they're trying to do, this is a document that largely transfers obligations from the regional council to LP. Very few obligations come back, and what we're trying to do here is just to set out the scenarios whereby compensation may be applied, but it's not necessarily going to be able to implement or describing the implementation of behaviour changes and good practice, but it is a marker in the sand.
Perhaps if we continue. Oh, sorry, you have follow up.
I actually want to go back just to ask another question about the insurance that you covered before, Andrew, because there's two elements to this. One is potential damage to the dam, and the other is damage to property from the escape of water. Is the insurance that you referred to before required to cover both of those events, or is it just the fixing the dam
So,
insurance?
yeah, firstly, under the project agreement, for a second, there are much more detailed insurance obligations than under the concession deed. So in terms of the comfort that you were looking for, Councillor Barker, it's taken from the project agreement with regard to the obligation that LP has to carry insurance. Those insurance obligations aren't yet fully complete, but they do require insurance of both the value of the infrastructure and the the public liability insurance provisions are actually in the concession deed. This is where the two documents sort of work together. So in terms of the, was that 46? Thank you. Yes, there was an obligation to maintain on the LP under the concession deed to maintain public liability insurance, public and statutory liability insurance at a level considered to be prudent, and in any event not less than an amount that's yet to be inserted. So that's one of the matters that I refer to requiring completion that needs to be completed.
Thank you. Continue with your presentation then.
Riveting
please.
presentation.
Yeah.
Or again, I suspect. Emergency powers, water user provisions. So the concession deed deals with water distribution and priorities and acknowledges that environmental flows, which are those that are required for compliance with the consents, and safety flows being, as the name suggests, water releases that are required for matters of safety, are have priority over other water. So they are first cab off the rank, if you like, before any water is made available to water users. And the ELP is required to ensure that all the water user agreements are consistent with the consents and with the concession deed. And on expiry of the deed, the water user agreements are transferred from LP to council or council's nominee, and one would expect council would nominate. I previously mentioned these what are called step-in rights. These are emergency powers. So council has step-in rights where there's an imminent serious risk to the health and safety of persons during an actual or potential dam break or overflow, or where there's a serious risk to the environment following the identification of contamination. And in those circumstances, council is entitled to assume management and control of the scheme. I believe that they're appropriate for a deed of this nature. In fact, in New Zealand, they are populated in a number of documents and seldom used. I think recently, though, everybody's eyes have been opened by what happened at Mount Eden, where the step-in rights were in fact exercised. I think it's unlikely council would ever want to exercise the step-in rights, but they because that would then you would then assume management and control of the dam. Because the operator wasn't able to, or wasn't either able or wasn't actually taking steps to avoid the issue, or to deal with the issue rather. But they are a safeguard there if something catastrophic goes wrong. And then question of what council's obligations are under the deed. There is another document council will be required to sign, which is a financier direct deed. We haven't yet been provided with that document, but I expect it to be a relatively simple document that essentially prevents council from terminating the concession deed while financiers are attempting to cure any breach by the LP. So if the LP has done something that is a breach of the agreement that would otherwise enable council to terminate, and the banks, as I described before, are busily trying to fix that and put things right, then I'm expecting that council will commit with the financier not to cancel the deed in those circumstances. And apart from the obligations to pay compensation or a termination payment, I don't consider that the council assumes any unreasonable obligations under the deed. In fact, Council has relatively few obligations. Most of the obligations are owed by LP back to Council. As I said at the start, it's you granting concession to the LP for them to operate. There was my insurance obligation statement, obligation to take and maintain public and statutory liability insurance. There are some excusing events which are in the nature of force majeure type events, generally beyond the control of the LP. If one of those events occurs and there's a resultant breach effectively by the LP of its obligations under the deed, then the LP is not liable to Council for a failure or a delay caused by one of those excusing events. And where that excusing event delays performance by the LP of certain of its obligations, LP is entitled to ask for an extension to the 70-year time frame, because it says, well, we've been prevented from doing this by an event that we're not responsible for, so can we please tack on that period of time that we've been unable to perform to the end of the concession deed so that we get our payback period, please. It's not a please, sorry. We will take that on. So the extension's commensurate with the effect of the excusing event. So if there's no delay as a result of the excusing event, there's no extension of time. And the final matter I raised was just expiry, 70th anniversary of financial close, subject to any extensions of time for the excusing events I just referred to. And on expiry, the infrastructure is transferred to HBRC, and so will come under the full ownership of that company. So that's the concession deed. Would you like me to go on to the project agreement?
Sorry, it reverts to HBRC or HBRC?
HBRC.
No further questions on that? Yeah, please. Or did you have a question on that? Sorry, Councillor Scott, I missed that.
I've got a couple of questions, and partly one of them will relate to the project, but I really want to pick on your point 3. Are you satisfied, given the recommendation that we'll be coming to later in the day, are you satisfied that the gaps that still have to be filled in are sufficiently minor not to alter the concession or our understanding of the concession deed in any way?
Well, let me answer that by giving you a couple of examples of what has to be filled in. So I mentioned, I have already mentioned that the minimum amount of insurance required to be completed. The minimum dollar value of the public liability insurance needs to be. That to me is a process issue. It's not really within the ambit of lawyers to say what that should be. That's more of a commercial question for council. So, and to be honest, most of the other items that remain to be completed are in that sort of realm. They're things like to do with water level rises and what's the threshold for triggers of water level rises, which are really technical things. So I think I'm hesitant to say I'm satisfied, because if they put a ridiculous propose a ridiculous number of, say, $1 for the public liability insurance, the answer will be no, it needs to be more. But I've no real doubt that we'll reach a landing on all of the things that are required. So I think I'm confident that we'll reach a landing on all of the matters that require to be completed.
Sorry, Christina, so I'm hearing you say that if we're going to approve this document today, it should be subject to the final version where those pieces are filled in.
Councillor, that's the recommendation number 4 says that, yeah.
Just if I could follow up on that question, Mr. Chairman, and that is that you are involved in representing council in those final terms.
Certainly, the document is being negotiated on the basis that it is subject to effectively mine and your approval. So,
Yeah.
yes.
And you can advise, if we do delegate to the chairman, you can advise the chairman accordingly.
Absolutely.
Yeah. Mr. Chairman, I did have two questions. May I ask the second one? That relates to the expiry date. Is there any provision either in the concession deed or both the concession deed and the project deed on the state of the scheme at the point of transfer on expiry of the concession deed?
But by inference, yes. The inference being that the obligation is to maintain the status of the infrastructure throughout the term of the concession period.
So we can be satisfied we get a working dam at the end of 70 years?
Correct. And you have audit rights to ensure that
Yep, thank you.
that's so.
Councillor Graham.
Thank you, Chair. Andrew, two simple questions. What's the dam company's obligation to the water users if they can't supply water? So if the dam is empty, we have a big long drought. That's my first question. You commented on the commercial upsides, but you didn't comment on the commercial downsides, and I would like your professional view on whether the securities in the contract you would regard them as sufficient. And you just alluded to credit support, so that the security is basically the 2-year credit. So two questions.
Okay,
One's a yes, no.
on the water user agreement, my understanding of the way that this works is an inability to supply for any length of time by the dam operator entitles the operator to firstly suspend its supply obligations and ultimately to terminate that's where yeah.
Can I perhaps step in here? Councillor Graham, on page 22 of the agenda is a summary of the terms for foundation water user agreements, and on page 22, which is the second of the 2 pages, it says that the water user will not be entitled to relief from its payment obligation in the event of a delivery suspension, and that delivery suspensions include suspensions for off-season maintenance and due to climatic water shortages. So, you know, that's a... Yes.
Yes. No, the second question is...
Security.
Security. So, there's no direct security that council takes in respect of the dam infrastructure. In fact, that must be offered up to the financier. So the financier in this project is going to take security over the infrastructure to secure its funding.
Yeah, I understand that. No, I'm talking about the water user agreement. The farmer goes broke, there's a downturn in commodities, goes broke, can't pay. We've got a 2 years banker's guarantee. Do you think that's sufficient security to put capital into an infrastructure? And would you do that in one of the buildings that you might have a ownership in?
I wouldn't like to offer an opinion on that.
Councillor, I think HBRC have actually answered that.
No, excuse me. Who would give us a commercial opinion? You're a commercial lawyer.
Yeah, a banker might offer an opinion on that. I mean, I guess what I would say to a client in connection with a transaction of this nature is you've got a wide spread of risk in terms of a take or pay contract with a multitude of different farmers, not all of whom are going to go bust, one assumes. If what you're driving at is the prospect of a downturn in farming returns and an unwillingness on the part of the farming community to pay for the water contracted, well, it's take or pay. So the only option really for farmers is to declare themselves bankrupt in some way, and I can't see that happening as a wholesale in a wholesale way across the farming
Just
community.
to clarify that, so you're saying there's personal guarantees in these contracts, because that's the only way you could go bankrupt. Otherwise, he just winds up the limited liability company, sells a few tractors and walks away. And in many cases, the farm is in different ownership. So what I'm saying is 2 years banker's guarantee sufficient security in your mind as a commercial lawyer? And I wouldn't ask my banker for commercial advice, I would ask you, Andrew.
I think.
That's what we're doing right now.
Yeah, I think the short answer to that is, I think that's a commercial risk that's acceptable, and I think that for one additional reason, in that so the first reason, the one I've already poorly articulated, which is that I can't see there being a wholesale default by the farming community. That would be talking individual people who this might occur to. And the second reason is that typically my understanding of the water user agreement in practice is that they are being signed up by the landowner, and so that generally represents a reasonably significant asset. Now, you don't have visibility into the financial capability necessarily of each and every farmer, but with most farmers, in my experience, are asset rich, perhaps cash poor.
We need to work through this one, because you're saying that I want to know from you, I don't need to look at the individual ones, but I want to know how many of these water user agreements or these contracts are secured by property, and how many are secured by limited liability companies, which may be farming. But that's a very relevant point, because I've raised this for 2 years now and haven't got an answer on this. Security is a very relevant point, and how are these contracts secured?
Mr. Chairman, the first point is that a payment default, the first recourse is to cease supply, just as a power utility would do. And the second recourse is the 2-year bank guarantee. I believe the level of risk is very low.
Mr. Chairman, the other requirement that you imposed back in June 2014 is that upon consideration of all conditions precedent, one of the requirements of HBRC is that their lawyer has to bring back to you a certificate of compliance that sets out all the water user agreements and all the terms and conditions of those. So, Councillor, your questions will be answered in discussion around that. Mr. Weirs doesn't have that information and wasn't asked to look specifically at down to that level of detail around water user agreements.
Yeah, so just, I just want to...
Mr. Chairman, no, you've hidden your finger out
I
there
have,
for
but
quite a while.
he's got have you got a follow
I've
on
got a
to this?
supplementary from the previous one, and we were discussing the concession deed.
Okay,
And now
great.
we're all over the foundation
Sure,
water user
absolutely,
agreements.
yeah.
So where are we going here?
Absolutely, no, point taken. So your question is?
Well, are we still on the concession
No,
deed?
yes, we are.
Right. Well, I think it's really important here that we stick to the fact that we're looking at this from a government angle, and I'm getting concerned that there's a whole lot of scaremongering being thrown into the debate around earthquakes. So just to go back to the robust risk analysis that was undertaken as part of this debate, it may be timely for the Chief Executive to bring some of those facts to the discussion. But my question for you, Andrew, we have a port which we're the primary shareholder. There is a very clear instruction as to the risk appetite for insurance from the shareholder, and being a public company, well, you know, publicly owned, it is conservative. So, are you satisfied with regard to the insurance obligations here in the concession deed, in the project agreement, that our conservative nature for the insurance, for the risk appetite, is going to be adequately represented?
Yes, I am. Essentially, the obligations. I can conceive of a scenario where something catastrophic occurs, an earthquake of a significant earthquake, where the dam becomes non-operational. In which case, you'll end up with an asset that's of no use. I can conceive of, but anything less than a complete completely catastrophic event, I believe will be dealt with appropriately by the insurance obligations that the parties will carry. In the first instance, the LP will carry, and with an obligation to reinstate. So,
And might I suggest probably no different to the insurance appetite that the governors of the port have if a tsunami hit as well.
So, sorry, we're ducking backwards and forwards here a bit, Andrew, but I just want to go back to the point that was being discussed before about the 2 years payment that's guaranteed through the water user agreements. And I just want to read back to you from this table that has given to us under credit support. The water user is required to provide credit support covering 2 years payment obligations from the first delivery date. Now, I take it that means that the payment for the first 2 years from the start of the dam is guaranteed, but there are no guaranteed payments subsequently. So if somebody does pull out, the money for the water that they've contracted to buy will not be paid for the next 2 years at all, only if it's in the first 2 years of the operation of the dam itself.
I'm sorry, I don't know the answer to that. I'm not sure whether that's a rolling 2 year period or a fixed 2 year period.
Chairman, have we still got Andrew Newman in the room? Can we get him? Because he can answer some of these questions.
He would know the answer to
Just
that.
a matter of process. And as the water agreement is not on the table.
Absolutely.
today,
I'll just
shouldn't
make
we-
that point.
Shouldn't we save all those questions until we have it on the table?
Absolutely, and it will be on
And
the
get the
table.
legal opinion
And it
on it
will be
then.
on the table, yeah, definitely. Councillor Barker.
I realise there's a couple of limitations here, but what I would like you to do for us, please, is just pick up. I've had shared Councillor Graham's concerns for a long time too, and I just want to be sure that we're getting ourselves in a position where we're not going to be left, so to speak, holding the baby. So what I'd like you to provide us is some advice on the event that there is an extended drought. The dam is empty, and people are going to be struggling to meet their cash flows. Under the current scenario, whether getting any water or not, they're going to have to pay for the water. So if the land is dry, it's still having to write a cheque for water which isn't being provided. What is someone going to do in those circumstances? Now, I would have thought if it was looking like it was going to be a long-term thing, given climate change, someone might decide to reject their contract. So what happens in those circumstances? How does this trickle down? What rights do we have? How long does it take? But that's also tied into Councillor Graham's point, which I agree with, is that so what are the assets that these are tied to? So we've got to know what the risk is here, and I don't see it.
So, through you, Mr. Chairman, I mean, these are the kind of questions that Deloitte will be analysing, or would be appropriate to ask them as part of the their final report back to you. That they have, it's been their role to look exactly at these kind of questions. What are the risks? What are the consequences of those for you as council, and make their assessment based on that. Mr. Wares has been asked to look at these documents from a legal perspective, to look at whether or not they place unreasonable obligations necessarily on council, or what those obligations are, and whether or not he considers them to be unreasonable. But in terms around risk around non-payment for a variety of factors, I think it's Deloitte will cover those off.
Councillor Balfour.
Well, Councillor, they've covered them off in the past, and I'm sure if they're questioned on them, they can cover them off again.
Well, it just has to be checked. So we're asking for legal advice. Deloitte normally provide you with economic and financial advice.
And risk advice.
And risk, okay.
Okay, Councillor Balfour.
Just to preview, when we do get to the water user agreement, there is a specific provision called trustee limitation of liability, which we would need to have explained by a lawyer, I think. But my question has to do with, the preface of this refers to a Tamatea agreement, and presents that in pretty glowing terms. Could you just remind us what our obligations are under the Tamatea agreement? What is it?
The Tamatea agreement is an agreement between HBRC and Te Taiwhenua o Tamatea. I'll just make sure that I am talking about the right agreement.
I think that might be a later discussion. I'm nodding. You asked me to nod, Mr. Wears. I'm nodding.
Thank you.
Well, the general question is just, what is this thing? Might be of general interest to the public. In fact, there is such a thing.
Mr. Mohi?
Yeah, I failed my lawyer's degree. Just basically, it's an opportunity for the Taiwhenua to be involved in the employment during and post building of the dam, so it's the distribution as well. And it's trying to get involved tangata whenua in the various work plans and environmental programs that, if the dam was to go ahead, would happen.
We're into this in public exclusion.
Sure. Okay. So any other questions, Mr. Wears, in public, considering that we will have...
We're moving along to the other...
Yeah, sure. Okay. On that particular issue. So continue, please.
Right, the project agreement. As Liz has said, the council is not a direct party to the project agreement. It's an agreement between HBRC and the limited partnership. And at a general level, the project agreement is more mechanical. It deals with the transfer of rights needed to implement the scheme. So it's focused on granting the rights to use of land, the transfer of the necessary consents, the transfer of any initial intellectual property developed for the scheme, and a transfer and disengagement process for the end of the concession period. And because the regional council is not a party to it, has no direct liability under it. Of course, HBRC is a party, and so to the extent that it has liabilities, and it does, then the economic effect of those is felt by council as the shareholder. Having said that, though, the first thing to note in terms of the project agreement is under the document, HBRC itself has no right to terminate the agreement. It effectively defaults that right, or passes that right of termination back to this council. So although you are not a party to it, you actually ultimately are the only party on that side of the document that's able to terminate, and that's for specified material breaches. And the project agreement and the concession deed are linked, so that termination of termination of the concession deed terminates the project agreement. I actually should clarify. Your ability is to terminate the concession deed, which then automatically terminates the project agreement. So it's effectively the same thing. I've summarised the rights and obligations under the project agreement. HBRC grants the limited partnership occupation rights for the site, and gives a number of warranties with respect to the land, and remains liable for some of the risks associated with the land, because my understanding is it's the landowner. HBRC transfers to the limited partnership the RWS consents, and the limited partnership is then responsible for compliance with the consents and for renewing and maintaining the consents during the life of the project. The limited partnership has compliance obligations, particularly with regard to health and safety in connection with the project. HBRC retains title to background IP, as it's defined, but grants to the limited partnership the right to use that background IP, and then IP being intellectual property. Intellectual property generated from the project itself belongs to the limited partnership. There are force majeure and excusing event clauses similar to those contained in the concession deed that I've already spoken to you about. The LP has insurance obligations, although, as I said, the details for the insurance have not yet been completed. And there are detailed provisions regarding handback and disengagement at the end of the project, and essentially they are designed to have a seamless transition back to ownership by HBRC. And I've seen nothing in that document that would give rise to concern to council. So that's the summary of that, Mr. Chairman.
Okay, there'll be further questions. Councillor Belford?
I would just note, because I think you're going to cut off my questioning here, two things that the...
Why start, Councillor?
Two things that I think the public ought to be aware of without getting astray here. One is that there are some very specific conditions precedent in this document, this agreement, that have not yet been scrutinized by this council. We will this afternoon. And personally, I would argue that there may be some question about whether those conditions precedent have been met or will be met in any short time frame. Secondly, there is a reference to all legal matters being resolved in this particular agreement before this agreement can have any effect. So I think those are two outstanding large issues with respect to the viability of this agreement, which we will be, I think, needing to discuss in public excluded.
With agreement from the other end of the table, no doubt.
Yes.
Okay. Thank you, Councillor. Any other questions? Councillor Scott, did you have a question? Oh, hang on. Councillor Bevan.
Andrew's not doing an analysis of the water user agreement, despite the fact that there's a table in here. Is that correct?
That's correct, yes.
Okay.
He has got a copy of has looked at copies of the water user agreement.
Okay. So, Andrew, this is slightly complicated and it goes across a couple of these documents. So you're aware that later in our agenda we'll be talking about the environmental flows that the council has in principle agreed to purchase, right?
Yep.
As a foundation water user or under a foundation water user agreement. So if my understanding is correct, if the dam doesn't fill up because there's not enough rain, then all of the foundation waters users' amounts of water will be prorated back to what is available, which would include ours. So even though we're using ours for environmental supplementary flows, and it's going to be dry, so it's really important, they'll get cut back just like everyone else's.
I'm not sure whether you're going to nod at me, Mr. Chairman, but the definition of environmental flows that's used in this document is not your purchased water. So the environmental flow is the water that's required to meet the RWS consent.
Yep. So the net effect of all of this is that any water that we purchase under a water user agreement, which is, as I say, is the next item on this agenda, it's not regarded as an environmental flow in these documents, and therefore would not be given any priority above any other foundation water user.
Yeah, as it stands at the moment, that's right. Yeah.
So the problem I've got with this is that in a dry year when the dam doesn't fill up is just a year when we'd want to maximise the amount of water that we can get down to the river to improve its health. So what is there to stop us from modifying the definition of environmental flows in this concession deed to include such water?
Through you, Mr. Chair, that there are two other parties to to this concession deed, and I think that's the answer to your question. That's what would, unless we could reach specific agreement with them, as discussed through the amendment provisions, that's what is essentially that offer is currently off the table.
Okay, so in effect, what I'm hearing is that if we're not able to change the concession deed definition of environmental flows to include this water that we might buy, then we are going to have to pay for it, like every other foundation water user, whether we get all of it or not, and we would not necessarily get all of it to improve the health of the river. That's the net effect of all of this.
Yet we would have exactly the same terms and conditions as any other foundation water user.
But I was assured earlier on that this deed could be amended
Negotiate
at any
an amendment,
time, assuming we successfully negotiated what you have in mind.
I think I understand that this is straying into the area of whether we go into
So
public
let's-
exclusion or not, but I'm pretty keen for us to have a discussion about that.
Well, let's do that at the time. Councillor
I
Grant.
just have one last question for Andrew. What's your legal view of us having a investment in a project which has pecuniary advantage to us, and on one hand, and being the regulator on the other hand? We've just been through an interesting conversation on conflict of interest about pecuniary advantage. What's your view on that?
Well, it needs to be managed, but I don't see any reason why it can't be managed. I guess the ultimate question, which is the question for you, for council, is this something that it wants to do? And if it is, then that sort of the conflict question can be appropriately managed in my view, and is in lots of these sorts of projects all over the place.
We manage it every day with the Port of Napier, councillor. We do. Okay, councillor Balfour, do you have another? Yeah, well, I think there was a limitation on the water user agreement as written here.
Yes. What I had said with regard to the water user agreement is I'd sort of kicked for touch on in discussion with the interim chief executive. Given that you are going to get a sign off from the person who actually wrote it and who is much more intimately involved in it than I am, I didn't see that there was a huge need for me to reinvent the wheel. So I have my knowledge of this agreement is less complete than the two we've just discussed.
Mr. Chairman, back in April, I first raised the issue of having Mr. Wares, as Stuart Webster did before him, give us an opportunity to raise questions about this water user agreement. I have 15 or 20 questions about this water user agreement, which is the foundation of all the rest of this enterprise and how it'll work, and what certain key provisions make, like Councillor Rex's concerns about liability. There's a very specific provision in here that appears to me to limit trustee liabilities in terms of who is signing these agreements. I'd sure like to know what that means. I'd like to know what, do you know what an AMO is?
It's a Mercedes car, I think.
I mean, an AMO is
It's
a whole brand-new section of this report, which I don't think any councillor at this table knows what an AMO is, but it deals with the nature of the trade of the let's say the pollution allowances, how they can be arrived at, what limits on them there are, whether they can be traded. A whole series of issues have been raised for the first time in this new water user agreement. We've had no explanation of what any of that means or what its implications are.
So while Mr. Wares is digesting it, I'm actually going to break for morning tea. for 10 minutes. Looking at the clock, sorry, a couple of minutes over time, but so 10 minutes. My understanding there's an urn coming out for the gallery to help themselves to a refreshing cup of English breakfast or coffee, and we'll be reconvening. I'm not sure, Mr. Bailey, we could have, never know your luck. We'll be reconvening at 1:45, please.